All right, good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is February 24th. It is 9:01. We are live via Zoom for our weekly meeting. We have folks Zooming in as we speak, got about 34 participants, which is good. We will start, as we traditionally do, with the roll call.
Thank you, Mr. Chair. Commissioner Bowe?
Here.
Commissioner Gonzalez?
Here.
Commissioner Mcgowan?
Here.
Commissioner Mesner?
Here.
Commissioner Nanjapa?
Here.
Commissioner Hackett?
Here.
Commissioner Robbins?
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Excellent. Welcome, everybody. Good to see everybody. We are here on Wednesday, February 24th, and our next agenda item is general public comment. And we only had 2 people sign up today, the first of which is Susan Noble from Commerce City, and I see that she is in the participant room. So if we could make her a panelist, we will start out with public comment from Ms. Noble, followed by public comment from Christy Douglas, who also is with us in the participant room.
May I start? This is Susan Noble.
You may. Good morning, Ms. Noble.
Good morning to you. Good morning, commissioners. In light of recent administrative approvals, including the Ivy and Edmondson pads, as well as several other Great Western oil and gas sites along the E470 corridor, we'd like to understand the official process regarding administrative versus commissioner decisions. Number 1, under what circumstances does the administrator have authority to grant approvals without notifying the public or without participation by the public or affected parties? Number 2, under what circumstances do approvals come to you on the consent calendar? Number 3, under what circumstances do you as the commissioners debate permit applications? And do the commissioners approve or deny any permit applications or other applications in private settings outside of a public meeting? Those are my questions for today. Thank you.
Okay, Ms. Noble. Well, I'm surprised you have some of these questions because you've participated with us throughout our rulemaking for the past 2 years, and I think you're very educated with regard to how commissioner actions occur. But I'll actually take you on and provide you with answers to all of your questions. Administrative approvals no longer occur. On January 15, 2001, the new rulemaking rules were put into place, and approvals are now done by the Colorado Oil and Gas Conservation Commission, that is us. Up until January 15th, 2015, the previous rules were in place, including objective criteria as required by the Colorado legislature. And under those rules, the administrator will be in charge of determining when 2As are approved or are not approved. And that is what occurred under the Ivy pad. Is the director made a determination that could occur. And so those 2s were approved, that's the APD, by the director before January 15th. The 2A for the Ivy pad had been previously approved, I think a year or 2 ago. Director Murphy, I would look at you to get a sense of when the 2A was approved there. But generally speaking, moving forward, all oil and gas development plans will receive attention by the commission for approval. The only thing that is administratively approved is the Form 2s. That's the wells themselves, and that's administratively approved after the oil and gas development plan has received attention by the commission. No approvals can occur via consent if my recollection is correct, if there's no objection. That's your second question. Your third question was, are approvals done by the commission? And yes, that is the case moving forward after January 15th. And then your fourth question was, does the commission approve or take action outside of a public meeting or in private? And the answer to that is no, we do not. We act in accordance with the Colorado Open Meetings Law, and our actions do occur during a formal meeting. Ms. Noble, do you have further questions?
Yes, I do then. So does that mean that the 5,000 wells that were in the pipeline prior to January 15th were all administratively approved?
Nope.
And where do we see, is that posted somewhere, what action was taken?
No.
Okay, and one final point, Mr. Robbins, thank you so much, Commissioner Robbins. I did participate in 2019 in the 500 series rulemaking, which was the initial rulemaking before this commission was put in place. I did not participate in any of the rulemaking in the last year and a half. However.
Okay, my apologies. I know you and I know each other, and I thought that perhaps you had participated in the 2020 rulemakings. But if you have further questions, feel free. My email address is online, and if you want to email me questions or if you want to have a dialogue, I'm happy to speak with you.
Thank you very much, Commissioner Robbins.
Thank you. Does any other commissioner desire to comment relative to the specific questions that were asked of us? Commissioner Mcgowan?
Thank you, Mr. Chair. And I think I think it's always good for us to, if folks have questions and they've forgotten or it's confusing. It's new for me too. And sorry, there's something going on in the background in my house. It was a little confusing to me at first that the permits themselves, the ODTPs, the caps will come before the commission, but that's an entire plan. And so once the commission has approved everything in it, the individual wells, when they get drilled, will be administratively approved, correct? Because the commission will have already approved the permit, the big permit itself, which encompasses everything that's going to happen within that footprint. And so I wonder if that's why people feel like things have been approved without going to the commission, perhaps.
Yeah, I think that could be part of it. Commissioner Mcgowan, I'll let Director Murphy speak to this as well. I think that part of the confusion too is this sort of sea change movement from we approved the rules in November, but they didn't become effective until January 15th. And then in the interim, and just for everybody's perspective that's listening in, and there's 60 of you, in the interim, Director Murphy was legislatively required to continue to apply objective criteria to pending Form 2As. And that is exactly what was supposed to happen. And so I think that the director did a good job of doing that. And as a result, the Ivy pad and the twos that were associated with it were approved. But going forward, Commissioner Mcgowan, I think you're exactly right. We will look at the oil and gas development plan, which is the 2A, the 2B, the guts of what's the proposed location supposed to look like. And then after that is accomplished, then the 2, which is the underground well, would be administratively approved, because we made, I think, the conscious decision that the important component for involvement by the public and stakeholder is actually the oil and gas development plan itself. Director Murphy, do you want to add anything to any of this that I'm speaking to? You don't have to, just.
I think you provided the appropriate color, and if it's ever appropriate and the commissioners want staff to kind of give a more formal run through of that, we can.
Okay.
Mr. Chair?
Yeah.
Could you or someone also remind me if there were a lot of rules that we went through, so it's hard for me to remember. Is there a required notification for when an operator is going to drill a well after the permit has been approved? Because I think that was another question, notification to the public. And so I don't remember if that was one of the things that required notification. Sorry.
Director Murphy?
Let me double check with staff, and yeah, we do, COGCC does receive a SPUD notice, and we also now receive a notice of construction, is my recollection. So when the 2A begins construction, we receive notice, and also before a well is drilled, COGCC receives a notice through the Form 42s.
I'll also just comment that in discussions that I've had with operators, I have let them know that I think more notice, as much notice of pending activities just makes sense. And so providing notice to people that are around the area before walls go up, et cetera, just, is a sensible thing to do for the members of the public that may be nearby. Commissioner Nanjapa?
Thank you, Mr. Chair. Yeah, I was also just trying to remember, I recall this discussion that the notice goes to COGCC from the operator. Is there also a notice to the local governments of those activities?
Director Murphy?
Yes, so our Form 42s, and Mike will cover this a little bit, it's an interesting dovetailing of the conversation.
Liquids noticing?
Right, so liquids unloading is a Form 42, but a Form 42 covers a lot of different notices our agency receives, and those are automatically provided to local governments. And then, of course, local governments under 181 have their own authority to determine if they want a different cycle of notice, et cetera.
Commissioner Nanjapa, did you have follow-up?
Yes, thank you. I mean, just the comment, as you made that, to the extent the operators can notify the folks around them, I think to the extent the local governments, if anybody's listening, can also ensure that they're letting folks in the area know what's happening. I think that's another piece of all of this that is not specifically required by COGCC to do, but is part of this sort of intent with the notices going to the local government. And so I think that's another piece of the whole thing that's a little bit hard to understand for folks, but is another sort of entity that is involved with receiving notices.
Very good. All right, at this point, I think we would move to the second person that had signed up for public comment, and that's Ms. Christy Douglas.
Yes, Mr. Chair.
Ms. Douglas, we see that you are a panelist now. If you want to unmute, we'd love to hear from you.
Ms. Douglas was having some, Ms. Douglas was having some issues connecting. She did not have a mic, so I provided her the phone number.
Yeah, I see that in the chat. That's great. Let's see. Everyone sort of bear with as we see if we can find Ms. Douglas.
Hello?
Yes. Hello. Is this Ms. Douglas?
Yes, it is.
Great. We can hear you now. If you want, you now have the floor.
Sure. My name is Christy Douglas. I come to you as a concerned citizen from Commerce City in Adams County. I'm a mother of 5 kids. I also have 5 wonderful grandchildren, and that's the reason that I'm here this morning. I serve as a co-chair for NRCC, which is North Range Concerned Citizens. It's a community group, and although I'm not speaking in their behalf, I wanted you to know that I do co-chair that group. A lot of the people who are in NRCC have come to you to testify, and they testified your last meeting. So I've been listening to public comment, and what I've noticed is that it's all community members who are coming to you now, and we're not seeing the oil and gas companies come and testify in their behalf. And I'm wondering why that is. I've listened repeatedly to Chris Nyholm's testimony. She was the first one to testify on February 10th. And I want you to know that you all are not hearing from the public. And I want you to know that January 15th is not the magic date that makes everything that was approved or permitted or put in the pipeline for permitting. It's not the magic date to make everything safe for our communities prior to that date. This is not using common sense. You've got to listen to the public. And I don't care if they come in with 3 different locations and you have to pick one. You don't have to pick any. You've got to start denying permits. There's such a thing as cumulative impacts. We're already impacted by the air that comes from Weld County. Please, I beg of you, start listening to us, and don't just use legislation as a front to be able to just keep doing what you're doing. Please protect the public and listen to the public. Thank you.
Thank you, Ms. Douglas. Thank you for taking time to present to us. We are listening and appreciate your comments. Ms. Amaro, that is the conclusion of the folks that signed up for public comment. Is that right?
That is correct, Mr. Chair. Anyone else has signed up?
Very good. We now would turn to the potential for a report from the Director Murphy, who may be with us. There she is. And I think as part of that report, we also have an update on the financial insurance informational docket.
That's correct, Chair, and I'll turn it over to Hearing Officer Thomas to run through that. I wanted to thank commissioners and folks listening in and our public commenters for engaging. The first piece I wanted to share with everybody, and I know each of you commissioners know this, but we successfully went through our Senate committee hearing for confirmation yesterday. The next step will be a floor vote, and we don't know the date on that, but I think it's, I've never heard such kind things spoken of Colorado Oil and Gas Conservation Commissioners in a confirmation hearing. And I just would want to reiterate how important it is that the folks who went through last fall, each of you seeing how to implement these rules is just a critical next step. On the rulemaking side of things, we're continuing to support the mission change implementation on the staff side. We've reduced our operator meetings to 1 a week as we've kind of slowed the pace of getting information out and are looking more into kind of the integral back and forth dialogue with local governments, stakeholders, and operators. Our highest priority recently for the forms has been finalizing a Form 9 for transfer of assets consistent with Rule 218. This week, we've released the templates that identify the information that would be included, and so operators who are in the midst of a transfer or planning for a transfer can begin compiling that information, and we would look forward to having the form finalized late this week or early next week. Our second form priority is the 2B. And again, I want everybody to keep in mind that while the form is not finalized, we do have a template available for operators to use to submit that critically important cumulative impacts information on the Form 2B. To date, we have not received an OGDP or a 2A for your review or decision. And as we do, I'll keep you updated. I do have a couple of updates about commission meetings. We've been planning a joint meeting with the Air Quality Control Commission and the Colorado Oil and Gas Conservation Commission. That is going to take place on March 18th. Our staffs are working to finalize an agenda and presentation materials. There will be a public comment session, and AQCC's public comment sign up will be the methodology used. We want to make sure we have a clear single point of contact for public seeking to give comment during that meeting. And so as we get closer, we will put information on COGCC's website, directing public members to AQCC's website to sign up. And right now it does look like that will be a day-long hearing, which I think really reflects the importance of the coordination across these two agencies as we implement our respective authority. And I'm much looking forward to that. In addition, on March 3rd, I have scheduled a presentation by the Colorado Energy Office on the greenhouse gas roadmap and a presentation by CDPHE regarding their pneumatics rulemaking for this commission. Those will take place at 9:30 and I think 10:45, but we haven't quite nailed the date down on the pneumatics. So next Wednesday will be a great day to tune in to understand some of the other workings of our co-regulatory agencies and the Energy Office. With that, I don't have a ton of other updates. We have received a PDC filing for a comprehensive area plan, which is exciting. We do have some Form 2s in, and again, we're waiting on 2As. With that, I would like to turn it over to Hearing Officer Thomas to talk through the financial assurance informational docket that has been opened and what that path looks like. I did manage to skip over one of the points I wanted to flag about upcoming commission meetings, and that is the informational docket for financial assurance presentation will be March 31st. And I know Hearing Officer Thomas will talk about that as well, but wanted to make sure we say it frequently so that people who want to participate can plan and set aside time. With that, Hearing Officer Thomas.
Director Murphy, if I could just ask a clarifying question, and Hearings Officer Thomas, you may answer this, but when you say that the financial assurance informational docket is the 31st, is that the day that we would review the submittals that we've received and have parties that provided information appear before us so that we could ask questions and sort of talk through the informational pieces we've received?
That's correct, Chair. Yes.
Great, thank you. Hearings Officer Thomas, good morning.
Good morning, Commissioners. One moment as we turn the volume down. Okay, sorry about that. This is Elias Thomas speaking. I will be the hearing officer assigned to the informational docket, and I am just providing an update on that process. Pursuant to your request, we have gone ahead and put together a notice and application for that hearing. It will be filed today in the e-filing system. That includes the date of the hearing, Wednesday, March 31st, as well as the deadline for the submission of oral comments and written comments, which that deadline is March 15th. In addition, that notice and application has the Commission's questions regarding financial insurance attached as Exhibit A. This notice and application, in addition to being filed in the e-filing system and available there for public viewing, will be sent out via email to a number of mailing lists through the Commission, and will also be posted to the Commission's webpage. As I said, the notice sets the informational docket hearing for Wednesday, March 31st, and sign up for oral comments will be due by Monday, March 5th, close of business, 5 p.m. Allow me to share my screen and I will show you where that portal will be located. So the portal for the public comment sign up will be located under the SB 19181 tab. From there, you can go to rulemakings, scroll down to financial assurance, and later today we will have a portal to sign up for public comment. This is simply to sign up to speak for public comments. For those wishing to submit written comments, that will also be due by close of business on March 15th. On the website, that will be located under regulations, hearings, and it will be done through the e-filing system. So individuals will need to go to the application and docket portal here on the right and register. The notice and application does contain instructions regarding this, as well as links to the user's guidebook on how to use the e-filing system. For those simply wishing to view documents that are submitted through the e-filing system, that's also available right here, the document search. There you'll just need to type in the docket number for this matter. And I'm not sure if I said the docket number, but we do have that. It will be 2102-00013. I believe that is all of the basic information I have, so I'm happy to answer any questions regarding other details to the best of my ability.
Thank you, Hearings Officer Thomas. Maybe a request from me, but if I'm on my other computer, I've got the main web page opened to COGCC, and I had requested, and I appreciate staff doing this, that we put the financial assurance informational docket questions kind of under news and notice. That's like on the very first page of our web page. If you could type up what you just said and put it in a docket that's on that first page, I think that would be very helpful, because then people who didn't actually listen to you this morning would know to scroll over to SB 19-181 and then go to the financial assurance page, et cetera. But I think if we could just, in very summation, note those two main components, how to provide written information and how to sign up for the public testimony, I think that would be helpful to the public.
Certainly, and I believe Commissioner Robbins, that is the plan once this is filed, and we will post it on the site for everyone to see, along with the notice and application itself. So we will be summarizing those instructions.
And also, if I may, Chair, including those instructions in the emails that go out to our, broad stakeholder lists.
Okay. Sorry, I'm being talkative today, but I had one other idea. And it has to do with, you just moved around the website and showed folks how to get to certain spots. And I know that each of the commissioners has recently received a educational session about how to use the e-form system. I want to throw out another idea. We have a YouTube page in which we have videos of our hearings. I wonder if we might be thoughtful about creating a little video that says how to navigate our website, and maybe get Mike Leonard or Jane Stanzik or others and just have that available, so that, because over the last several weeks, people are very excited about the new transparency with the commission, and our website is loaded with information. But I learned a lot about the e-filing system from getting a tutorial. We obviously don't have time to do tutorials for each individual that wants to do it, but using YouTube and kind of a video, I think we could start to create some informational pieces that people could then just at their own leisure go watch something like that. So I don't know. I recently bought a smoker, and there was a YouTube video that I was supposed to go watch to how to put it together. And it was so easy to kind of figure out how to put the pieces together. So I'm wondering if maybe we could use a similar piece. And this is probably something I should have taken offline with you, Director Murphy, but I was wondering. So there you go.
Thank you, Chair. I think it's a good question. I think we do have a similar tutorial for the e-filings, but Hearing Officer Thomas, good, he's nodding yes, I didn't get it wrong. But I think we can work with Megan. I understand that our website is complicated for those who are not using it day in and day out the way many of us are. So let me think on that. Let me work with Megan. She has better sensibilities about communications than I do. I'm a little bit too far into the weeds, I'm afraid, and see what can come of something like that.
Thank you very much.
And Chair Robbins, if I may,
Yes.
Director Murphy is correct. There is a training video regarding the e-filing system specifically, and it is located in that same area that I highlighted. I will show everyone once again.
Yeah, go ahead and share your screen and show us again.
So under regulations,
Hold on.
hearings.
Wait. Let's get to your screen first. Okay, now go for it.
Under regulation hearings, you'll see this whole little area titled Hearings e-filing system. There we have access to the document search, the docket filing portal, the guidebooks, FAQs, and then right here is a link to the training video for the e-filing system. So all that is available there. It's just a matter of getting to this page.
Excellent, great. Well, thank you, Director Murphy, for indulging us on that. And I agree, let's use the capacity of our Public Information Officer, Megan Castle, to help sort of frame this thought. Okay, so we've received the Director report and the Financial Assurance Informational Docket. I think next up is Mike Leonard, our Compliance Unit Manager, to speak to us about something that we've heard a lot about recently, the Form 42 notices regarding liquids unloading in general, and in particular with regard to the town of Erie.
Chair, I may start if that's okay. Thank you. And I think Angelica will be pulling Mike in and hopefully driving some slides for us. While she's working on that, I'll take a little bit of time to provide some context. Staff does continue to support the town of Erie with their questions around the May site and understanding oil and gas activity generally. We attended a town meeting on May specifically, and then we've continued to engage with the town on follow-up questions and have been closely partnering with CDPHE in this endeavor and in answering these important questions. We have heard a lot of concern from public about the way COGCC discussed the CSU 2019 public health study. And we continue, and I want it to be abundantly clear that we continue to value that study and it informed actions that have taken by COGCC staff after its release, as well as the Commission's decisions during the rulemaking. And we also understand that the scope of the study is really focused on open flowback operations. But it provides slightly less direct information about other types of flowback information. And so understanding what the study says, what it applies to, and how that should guide our action is really important. I think the other piece that's important in this space in particular is that even before the study was released, COGCC had begun requiring closed loop flowback systems because they are more protective of public health than an open flowback system. Mike can talk more about the differences in flowback systems if that's helpful. And so I guess I just want to be abundantly clear that the reason that Deputy Director Cuthbertson clarified in the Town of Erie meeting about the scope of the CSU study is related to making sure we understand the context of the study and the context of operations at issue. But in no way did those comments diminish the importance of that study or how this agency values it. It is an important piece of information, and I think it will continue to shape our operations. And at some point, we hope that there will be further study to understand not just open flowback systems, but closed flowback systems as well. And with that kind of prefatory pieces, I'm gonna do something that's even more dangerous for me, which is I had asked Joel to prepare to talk about the Form 42 notices and how it integrates with CDPHE. He unfortunately had a conflict this morning, so I'm going to walk through what he had prepared for you all. And so As you recall, the Form 42 liquids unloading conversation, well, there's two pieces of that, right? There's the Form 42 conversation, and one of the Form 42 notices is for liquids unloading. We had a lot of dialogue as an organization about Form 42s, when they should be submitted, at what time, and how. And one of the pieces that I fairly emphatically brought forward around receiving notice is that COGCC needs to receive notice at a time that fits into its operational flow. And so there were a number of folks who wanted notices much earlier and provided more broadly and about different activities. But we as an organization use notices to drive our actions. And I think that will become more clear as we work through it. So next slide, please. Thank you, Angelica. So we're going to talk a little bit about the rules that cover unloading, well configuration and equipment, which will be Mike, of course, description of operations, description of unloading, and then Mike will close out with a little bit of information about Erie, specifically as it relates to the Form 42 notices that we have seen come in. And again, that Form 42 notice is broader than just liquids unloading. So next slide, please. So both COGCC and CDPHE regulate well liquids unloading. COGCC Rule 405S governs notice, and it requires an operator to submit a Form 42 field operations notice of well liquids unloading no later than 48 hours before the event occurs. However, if extenuating or unexpected circumstances exist, such that providing 48 hours notice would require an operator taking alternative action that would result in a net increase in emissions, then the operator can provide less than 48 hours notice. And so as I go back to the dialogue that we had around the liquids unloading event, there was this question about what about emergency or very quickly situations that arise very quickly that need more immediate action. And I think that I understood that to be a rarer set of circumstances than the broader set of circumstances that would require well liquids unloading. And so we wanted to provide an accommodation for those unique circumstances, but also maintain broadly the requirement that COGCC receive notice before a well liquids unloading event. As I kind of alluded to earlier, as with most Form 42, COGCC automatically provides to the relevant local government with electronic notice when the Form 42 is submitted. So when it hits our system, it automatically goes to the local government as well. There's not a delay where COGCC staffers are reviewing or approving or taking action before that notice goes to the local government. And although it is not specified in the rule, the statement of basis and purpose explains that the Commission will provide the Form 42s for liquids unloading to our partners at the Air Pollution Control Division upon request. Again, this to me was an important area of collaboration between COGCC and CDPHE. And again, the timing of receiving the Form 42 48 hours in advance allows staff to determine whether a field inspector should be deployed to witness the activity. And then broadly, bringing in notices of these events allows staff to track well operations and understand responses to local government or other inquiries. Next slide, please. The substantive requirements for liquids unloading are found in Rule 903D1E. I love that Joel included in his script, as you may recall, which I certainly don't, but I will go ahead and convey what he shared, which is 903D1 does provide a list of exceptions on to the ordinary prohibition on venting and flaring during production. Because liquids unloading results are the release of natural gas into the air, in other words, venting, it is one of the enumerated exceptions. However, for liquids unloading to meet the exception, an operator must employ best management practices to minimize emissions consistent with Air Quality Control Commission's regulation that we'll discuss shortly. Again, these best management practices include capturing or flaring natural gas that escapes into the air during liquids unloading. 903D1E also clarifies that the practice of swabbing, which Mr. Leonard will describe, falls within the definition of liquids unloading. And 903D1 also repeats the notice requirements under 405S that we've discussed. And the purpose of Rule 903D1E is to acknowledge that well liquids unloading is often a necessary form of well maintenance, while minimizing emissions, and the loss of saleable natural gas during that process is important in our regulatory sphere, which is why we've enacted regulations around it, and specifically with best management practices. By requiring notice, it also serves as an information gathering function that will allow both the Commission and Air Quality Control Commission to better understand liquids unloading. Next slide, please. And so now I'm going to talk at a very high level about air quality control regs because they're not my expertise, and I'm certain that Sean can chime in if he wants to provide more color or description. So like 903 D1E, the air quality control regulation requires operators to employ best management practices to minimize emissions during liquids unloading. It also requires operators to explore options for unloading the well without any emissions. Last, it requires the operator to be present on site during the liquids unloading event to monitor the situation and ensure maximum emission limitations. Next slide, please. The AQCC regulations also require operators to keep specific records, which along with the Form 42s reported to the Commission will aid both agencies in improving their understanding of liquids unloading and the efficacy of various best management practices. Next slide, please. Whoops, it looks like it jumped a little bit too far. So with that, the AQCC also requires an annual report of the liquids unloading and to include various information about it and what techniques were used to reduce emissions. And with that, I would like to turn it over to Mr. Leonard to talk about the technical side of liquids unloading.
Mr. Leonard, could I ask a question or ask you to address a fundamental point here as part of your presentation, which is, can you clarify for the lay people, including myself to a certain extent, what is liquids unloading and why is it, you know, what happens, why does it happen, why is it important, all of that. We've kind of like jumped past what it is and we're talking about the notices around it.
Sure, and that's what I've developed this presentation. I thought it would be good if we did describe the process, both the normal production process and then the liquids unloading process, and maybe talk a little bit about you know, why notice, you know, 48-hour notice is not always the most favorable time frame. And if we could just go to the next slide. One other thing I'd like to mention about notices, as you recall during the rulemaking, we have multiple notices that go by Form 42 to the local governments unless they opt out of receiving specific notices. Some go to also the proximate local governments. And then we do have other notices that go that are not Form 42s, but have to go by rule. So notice of flaring, spill notices, things like that have to be reported to the local governments as well. So there's several notices that are required. And I'm glad Director Murphy helped me out with the AQCC rules. I would have probably been lost. All right, so let's start with this first cartoon that I've put up here. And it depicts the vertical section of a wellbore in which the production equipment operates. Now there's variations of equipment configurations out there. There's multiple plunger stages and other lift equipment, but this is the basic concept of the plunger lift system in which liquids unloading has to occur. As you'll see at the bottom of the picture, the gas and liquids enter the wellbore, and they enter the tubing and the casing sections of the wellbore, but they can't go anywhere. They just build pressure because at the top of the slide, and I've highlighted it in green, there's a motor valve and a controller, and that motor valve is closed. When the wellbore gets to a designated pressure, or in some cases there's a specified period of time, and this is worked out through operations situations, that controller opens that motor valve. Obviously that pressure downstream of that motor valve has to be less than the wellbore pressure. And that well pressure then lifts the liquids and gas in the tubing to the surface. The plunger, or as it's depicted here as a piston, is below the gas and liquids and forms a seal that help bring that product out. It's important to note that although the downstream pressure is less, obviously, than the pressure in the well, or it wouldn't go anywhere, it's still elevated well above atmospheric pressure. And that produced gas must be able to enter the sales stream. The pressure in that sales stream is typically controlled by a midstream purchaser. And that midstream purchaser pressure can vary based on how much gas that purchaser is moving and the processing capability it has. So next slide, please. So now we have our equipment configured in the same way, the same wellbore. However, as you notice, the wellbore liquids, excuse me, have risen to a point that the wellbore pressure can't push that product out. That liquid weight is greater than the pressure that product, greater than the pressure can push it out. Now, this can be caused by numerous situations, but just a few of them. There may have been an unanticipated influx of fluid. So the well that normally cycles this much fluid on a daily or hourly basis, for whatever reason, brought more liquid into the wellbore, and that's a naturally occurring thing. That downstream or midstream pressure, line pressure, may be high. That may be because that midstream purchaser has curtailed back their processing facilities to work on their plant, or there's more gas coming into the system, many things like that. A third problem happens is that the seals on that plunger lift or that piston, they wear out a little bit, and they allow fluid to bypass as it's pushing it up. So as I'm bringing fluid up, I'm also dropping fluid. So I'm not clearing that tubing completely for each cycle, and it falls back. So next slide, please. Okay, so now we come to unloading the well. So how do we do that? Well, if line pressure is the problem, maybe you can just wait until that line pressure goes down, that downstream purchaser pressure. You might be able to wait. But keep in mind, as you're waiting, more fluid's entering that wellbore. So that wait time may be problematic, as it's causing the well not to be able to cycle when that line pressure does go back down. The second and most common way to do it, excuse me, is to bypass your separation equipment. So your fluids come out of your wellbore and go to a separator that as we know, it separates the oil, gas, water, and into separate products and sends them to different places. You can bypass that separation equipment and open that well to atmospheric pressure at a tank for a period of time. And again, as it was mentioned before, this does release or can release gas into the atmosphere. If the influx is so great that by opening that to that atmospheric pressure, or if we waited too long, or for whatever reason we can't bring that fluid up, then you have to bring in a truck-mounted swabbing unit. And this is a smaller rig-looking equipment, and it basically what it does is it hooks up to the very top of the tubing. You'll notice there's a lubricator cap. You take that off, you install some equipment, and you run a steel cable off a spool with a cup on the bottom of it. And you run that down into the fluid, and then you pull that steel cable, or you roll that steel cable back up, and that cup expands and brings that fluid out. And again, this is a process that's normally performed by sending that product to an atmospheric tank. There is equipment out there that can swab against line pressure, but it's very limited, because swabbing against that pressure as you're pulling that line or that cable out of the hole, and you're increasing the back pressure on the top of it, there's a safety concern that line can we call it parting the line, but the line can actually break, or some of the other equipment can break. This third process is the longer process, and this is why one of the reasons why the rule was the allowable is either 48 hours or as soon as possible, because when a lease operator shows up on site, they can normally tell that well's starting to load up. If they, in many cases, if they right then and there can unload that well, we can keep that unloading time to, maybe less than an hour. If we have to wait 48 hours, again, think about that liquid's building up in that well. Now we may end up having to bring in this truck mounted swabbing unit, which is going to increase the amount of time that we're going to have emissions. So shorter amount of time versus the longer amount of time based on that notice. We're still requiring the notice for that. The operator still has to send us that notice saying that they unloaded that well, but it's not that 48-hour notice, and it's typically within 2 hours. Next slide, please. So let's talk a little bit about ERIE's notices, and I ran a query here late last week, and between January 20th and February 19th, ERIE's received 71 Form 42 notices. Now keep in mind, they've also received other notices as required by rules, and I think some of their rules as well, that operators give them notice. But this is just the 42s between January 20th and February 19th. And these are for activities within the town limits or proximate to the town limits as required by the rule. So not all of these are in Erie proper, but they are proximate to. As you can see on the slide, there's been 46 notices for liquids unloading. And I'll show you on a map here in just a minute where those locations were. And these are wells that are located at 7 distinct locations. So it's at specific locations. At 21 of these wells, the operation lasted more than 1 day. So they may have had to swab. In other cases, there are multiple wells on the pad, and they would do one well 1 day, and another well the next day, and another well the next day in that type of order.
Mr. Leonard, can I stop you real quick and ask a clarifying question? So, okay, so we see these 71 notices and then 46, et cetera. I just want to clarify for the record. This is a normal regulated activity, right?
Correct.
And it's not problematic or uncalled for. It's part of the operations that you regulate, right?
Correct.
And am I also right that this would have been happening in 2019, but notices would not have gone out, because what happened on January 15th is we now have a notice to local government about this regulated activity. Do I have that right?
Yes, sir. That's correct. And this was put into rule so that we started to get an idea about where these activities were happening, and maybe we could start mapping them out and seeing, what best management practices were taking place, and if potentially more best management practices could be developed. But we had to get an idea of how often and where this is happening.
Okay, I just wanted to clarify for the record, just so that everybody understands that this is a regulated activity that you regulate, that we regulate. It's not scary, it's not uncalled for, it's part of oil and gas operations. And the significant change that has occurred is that notices to local governments are now happening, so they're aware of it.
That's correct.
Thank you. You can proceed.
Thank you. So one thing I do want to mention, where it says 21 lasted more than 1 day, this is not to infer that these wells were open to the atmosphere 24 hours a day, because as you may have seen, and you'll probably have to go back in the slides, but under AQCC regulations, it's required that someone's on location when that well, the operator has a contractor, an employee, someone responsible party at that well while it's open to the atmosphere. That's one of the best management practices, because as soon as that well unloads, then we want that well closed in and put back into the normal cycle. Some of the other notices that were automatically sent, there were 19 notices of frac. Some of these were on the May J pad, some of these were on the windsock, which are both proximate to Erie. There were 3 notices of starting of plugging operations, and I believe one of those was actually in Broomfield, but proximate to Erie. 2 notices to temporarily abandon wells. This was for horizontal, what we call horizontal safety prep, and 1 notice of flow line abandonment. Next slide, please. So I didn't map out all the other notices, but I mapped out the locations where these liquids unloading events happened. And for reference, I've placed for those of you that are familiar with Erie, well, and to give you an idea, I-25, you can see on the right-hand side of the screen. East Baseline Road is Highway 7, and then County Line Road to the west. I placed a box around the Colliers Hill subdivision and mapped out the May J pad, and then the 7 distinct locations where the unloadings event happened over that period of time that I mentioned. It's important to mention here too that you can find this same information. Erie has a great website where they're very transparent in the notices. When we send them a notice or the operator sends required notices, Erie posts those on the website and adds an addition, maps them out as well. So with that, I can take any further questions or clarifying, whatever you need.
Thanks, Mike. I think the one thing I wanted to clarify is that the Form 42 for liquids unloading is a new requirement, but the other notices that Mike had listed, we would have received notice of those prior to January 15th also. And other than that, I guess maybe we should have reordered that presentation and started with Mike and ended with the regulatory requirements, but it's always a toss-up for me in terms of figuring out whether it's better to understand the regulatory context and then the operations. But I appreciated your questions and timing, Chair.
Yeah, no problem. Thank you both for the presentation. It's very illuminating. I think what this is, sort of shining a light on is that this, 100% more transparency that we've created with regard to our rules and our notices has indeed daylighted some of the things that operationally, that's what happens. And I guess my point is that I've learned from discussions with you guys individually that this is a normal operation. It's not problematic. It is part and parcel of development of the mineral resources, and we regulate it and we make sure that it is appropriate. And so that was kind of the line that I was angling in on. And I also don't want to diminish the fact that we've heard a lot from the public about this. That's great. That means that people are paying attention to what's happening. But I think we need to have these informational sessions because it helps people understand what is going on around them. And I think that this communication that our rules now call for provides more perspective about what's happening, and that's all good. I just think we need to make sure that we get out ahead of the ball to establish what it is, what is the is here, what is happening. So with that, I'm looking to my other commissioners if there are questions, thoughts, comments. Commissioner Hackett.
Thank you, Mr. Chair. I had a couple comments. I'm not sure if I have any questions yet specifically. First, on the 2019 health risk assessment, again, that was a CDPHE commission study that was conducted by our contractor, ICF International. It used emissions data that was collected by Colorado State University. and monitor or modeled that data to understand potential impacts based on those modeled data. But I did want to thank Director Murphy for that additional clarification on the study. For a little bit of background for the rest of the commissioners and other folks listening in today, I did attend the Erie Town Hall with COGCC staff. I heard Mr. Cuthbertson's comments about the 2019 study. I personally understood what he was trying to get at with talking about one of the limitations of the study, that being that the study collected emissions from activities specifically that largely relied on the use of open flowback tanks, which is a practice or a process that's being phased out or has been phased out. So while I understood that, I recognize that communicating these types of technical issues to people who might not have an engineering background or a legal background is certainly a challenge that us regulators struggle with constantly. And there definitely is a lot of room for improvement in how we communicate with the public and being clearer and using more plain language. And I struggle with that myself. So, but I did want to say, again, I appreciated that additional clarification. Director Murphy, I think you have accurately discussed some of the limitations of the study, while still recognizing that in spite of these limitations, which all studies have limitations, this study still is a valuable piece of research that is a piece of the puzzle that helps us better understand potential impacts. Also, just wanted to note that while it is a useful study, it's not the finish line, it's not the end all and be all of studies. Additional air quality monitoring, health risk assessment, research, a lot of this still needs to continue to happen and frankly should be accelerated to better understand potential health impacts. So just wanted to add that piece on the study itself. And then in terms of what regulation number 7 requires, the Air Quality Control Commission regulation. Thanks again, Director Murphy, for discussing that. Thank you, Mike, or Mr. Leonard, for your presentation on the technical aspects of what well liquids unloading entails. I did just want to say that I think your representation of what the air quality regulation says is accurate. That's also my understanding. So I think you did a good job presenting on that there. One thing that I will add to what you presented on is one of the first rulemakings that the Air Quality Control Commission put together to implement Senate Bill 181 was their December 2019 rulemaking, which included a number of things. One thing specifically was an improvement to their well liquids unloading rules. And those rules have been in place, the requirement to minimize emissions and the requirement to use best management practices. Those have been in place since 2014, but it was in December 2019 that the Air Commission strengthened those reporting and record keeping requirements. And like Chair Robbins, like Mr. Leonard have alluded to, just like the notification requirements, the increased notification requirements that COGCC has adopted in the emission change rules, these increased reporting requirements that the Air Commissioner is requiring of operators, this is also helping us better understand more about the process, about how frequently these events are happening, helping us line up the appropriate infrastructure and staff to be able to respond to these events and figure out how to fit them into our routine inspection queue. So just wanted to provide that, and also happy to try and answer any additional questions commissioners might have about CDPHE's regulations.
Thank you, Commissioner Hackett. It's always great to get your perspective and have you with us from bringing the CDPHE angle in. I'll transfer over to Commissioner Mcgowan, who also had a comment or a question.
Thank you, Mr. Chair. I had a couple of questions, and I'm not sure who's going to be able to answer them, but one was, so in addition to when staff goes and looks at a site and then realizes they might have to do liquids unloading, is liquids unloading also part of like regularly scheduled maintenance? So every May I go out and do liquids unloading at X, Y, or Z pad, or is it only based on a visit and or perhaps equipment that's keeping track of pressure or whatever on site where they realize they need to go then do liquids unloading? And I'm getting at this question because I think just from some comments I've heard from folks who live in communities, the 48 hours works for us as a commission for our business purposes, how much in advance we need or would like to have notification. Maybe as a citizen, you'd like to know a little further ahead of time. And so I'm wondering how much of this could or would be regularly scheduled, and you might be able to get more than 48 hours notice.
Mr. Leonard?
So thank you. Good questions. First, I'd like to mention that our staff, the COGCC staff, is not out looking at the pressures and you know, saying the well needs to be unloaded. This is
Sorry, I meant the
operator.
operator staff.
Yeah,
Yeah.
that's. I think that's okay. It's not commonly a maintenance operation, a planned operation. It is commonly. That's not to say that it doesn't happen. That I need to, you know, as an operator, I need to do something to clean my tubing up. As may or may not know, there's paraffins in the oil, and sometimes they build up on the tubing. So they may have to go in and clean that tubing up, which that is easily the 48-hour notification. It's the the unanticipated well loading up that requires the shorter notice. Does that help your question?
Mm-hmm. Thank you. Could you tell me too, do we know what is emitted during liquids unloading? I know that we're trying to practice best management practices, but I'm wondering if anyone's looked into what we think is emitted during this activity.
I don't know if anybody's looked into it. It's going to be the formational gases will be emitted. The liquids will be captured in the tanks, and then the formation gases will be what's emitted.
And then I think for me, I would now that we're not that we weren't keeping track before, maybe it was less transparent. I'm wondering if it's possible for us to maybe somewhere down the line have a presentation about the notifications for liquids unloading and kind of looking at it from almost a statewide view where we see where it might be happening more frequently than other places, how often it's happening. And that might give us a better understanding of whether or not we want to have a more specific with the Air Quality Control Commission about, so for example, I know that they have the Camel and they're about to get another sniffer mobile, getting more data about what happens during unloading and how frequently it's happening. And, you know, there might potentially be some discussion around if it's happening a lot, there could be ways for us to look at cumulative impact, or maybe there isn't a whole lot being emitted during that activity if there's best management practices, but it's hard to tell because we don't know what we don't know. And maybe there are some things we could start to look at or gather data to help us make informed decisions and have some good discussions with the Air Quality Control Commission.
Commissioner McGowan, I think that we could pull together after an appropriate period of time. I mean, 6 months is kind of what comes to mind for me, but I don't know if that's necessarily correct, and look at that geographic distribution and frequency to help inform some of those questions. And I think that would be reflected based on the notices received. Mike, I don't know if you want to add on at all.
Sure, and I think everything that you mentioned, as far as getting a handle on where and when and how often these happen, is the reason that you all adopted this rule. Because as Chairman Robbins mentioned before, and I mentioned, this has been happening for quite some time. It just, we didn't have a good handle on where, when, and how often. And that's what we're looking at. And maybe, from that point, do BMPs need to be invented or developed, or however you want to put that, to handle some of this? It's important. Everyone might think that, well, I can just unload and burn that gas in a flare, but again, you have to remember either I have to take the time to get that flare out there, or that back pressure that it requires to run that flare might be more than what allows me to unload that well. So that's a lot of the things that we'll have to look at as we move forward.
Commissioner Hackett.
Thank you, Mr. Chair, and thank you, Commissioner McGowan, for those questions. I did want to just follow up on those. So first of all, just to Director Murphy and staff, please let me know if CDPHE can assist in any sort of information about that, or if I can help coordinate any discussions with the Air Pollution Control Division about that. And then also, Commissioner McGowan, you had mentioned the sniffer van, so just wanted to let folks know that we are planning on getting that van. Unfortunately, there was a little bit of a delay in our air quality contractor getting the van from Ford. There's a lot of people buying camper vans these days, so we wouldn't expect that to be out in the field. Hopefully July, August. So unfortunately, that's not helpful to the community right now, but just wanted to let you know that going forward, absolutely, these are the types of activities we would be interested in getting heads up about, and trying to send that mobile van by to drive by and learn more about the emissions that might be associated with these events. So we'll be looking forward to additional conversations with COGCC staff once we have that equipment, how best to prioritize it, and whether or not well liquids unloadings or other maintenance events that might have emissions, how those might be able to fit within the priority schedule of deploying that thing. So I'm happy to answer any questions about that as well.
Thank you again, Commissioner Hackett. Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you, Commissioners Mcgowan and Hackett, for your questions and comments. I'm assuming that this fits in with our cumulative impacts database, but I was just trying to figure out how, and if anybody could comment. You know, are we recording just the as Mr. Leonard mentioned, you know, that with the rule, we are now getting more information on where and when it's happening, and et cetera. Are we putting that into our CIDR database, or is that, would that have to be more tied to once we know more about what gases are, you know, being released, or that type of thing? I'm just trying to make sure I'm understanding sort of how and where we're recording this.
Thanks,
Director Murphy.
Thanks. Sorry, Chair. Thank you for the question. So the way we built the CIDR database is really fairly forward-looking in terms of what permits are coming into us going forward. The Form 42 for liquids unloading applies to all existing wells. So we're gathering data about wells that were drilled 30 years ago, 50 years ago, or last year. And so there isn't a perfect corollary between those two data sets, or in terms of data set's not the right word. Mike should be talking about the database components of this. But again, CIDR is kind of built discreetly as a forward-looking piece. I would need to talk to our team about how we integrate other types of notices into it. We've been so focused on getting the layout in place to go forward. And we haven't, and I think that was one of the acknowledged limitations of the CIDR database, is that it doesn't gather data about existing facilities. And someday if we can find some research institution that wants to build that out for us, that could be a great outcome. I can go back and think about how these work together. I mean, fundamentally, the way I've been thinking about gathering more data and what it would mean is that we can pull all the Form 42s filed, understand their geographic distribution, understand whether we're seeing it more frequently from horizontals versus verticals versus directionals. Is it basin specific, or is it some piece of geology? And that, I think that's a good informational data set to pull from, and how that actually integrates into a cumulative impacts analysis. That feels a little bit like step 2 to me, but I'm certainly more of a director than a scientist at this point in time. And so if there's a way to correlate that or look at it differently, I'd welcome, you know, your expertise in particular in that arena.
Thank you, Director Murphy. I appreciate that explanation. And I know that this is all sort of, you know, still early in the process, and we're trying to figure out sort of how we track and record and understand those different bits of information. But yeah, this is just a piece that I guess hadn't really occurred to me in terms of how we may or should think about this in terms of that database. So yeah, to the extent that we can keep kind of talking through that or thinking through it, I'm happy to help out behind the scenes.
I'm looking at the screens to see if other commissioners have questions around this presentation, this topic, et cetera. This has been very, very informative, Director Murphy and Mr. Leonard. I want to thank you for being responsive to the issue that has been addressed via our public comment. I want to thank our public commenters for bringing the issue to our attention. I think always generating dialogue around issues that we find as a result of our new regulatory regime and the notices around that is really an important good step for all of us. All right, seeing no more questions, I think we have exhausted this topic. It is 10:15. We have a couple more items on our agenda. I'm just going to keep plowing through unless folks feel like we should take a quick break. And seeing no hands raised, going to continue. I believe now we have a presentation from Hearing Officer Peskin concerning Wellington Operating Company.
Good morning, Commissioners. This is Hearing Officer Peskin. Chair Robbins, if I may, it's not actually my presentation. I'm just a hearing officer that's going to be introducing this. We have two staff members, John Axelson and Rick Allison, who will be giving the Commission a presentation regarding a request for a 6-month extension for a Wellington discharge permit. So I will let Mr. Axelson take it away.
Thanks, John. Good morning, Commissioners. It's nice to see you all again. So yeah, we're going to discuss the extension request for a discharge of treated produced water to groundwater by Wellington Operating. And I just want to explain a little bit. I think normally you would expect the operator to be making this presentation since they're requesting the extension. And they submitted a renewal application in August of 2020. And they have really tried to provide all the information needed to renew this permit. And as you know, there's been tremendous change to the regulatory environment. And as we went through the upgrades that were needed for the permit, we met with Water Quality Control Division. There was just no way to get a final permit in place for your consideration by the time that this existing permit had expired. So this wasn't due to the operator really dragging their feet and coming in at the last minute trying to get an extension. It's really a result of the regulatory environment now. And so we felt it was important for staff to kind of give you the background. So I'm joined by Rick Allison today, who's the COGCC Environmental Protection Specialist. He's been working with Wellington to really get the discharge permit renewed. And then Randy Evans, the Wellington operator representative, is also available for questions today. And Angelica, if you could put our presentation up, please.
Yes, in just one moment.
Thank you. Luckily, I noticed that, or I would have just kept going. Thank you. And go ahead and go to the next slide, please. So as mentioned, I'm going to provide the background information on the Wellington discharge to groundwater. You should know that this is a one-of-a-kind discharge, as far as I know, that has been issued by COGCC in coordination with CDPHE Water Quality Control Division. I'll discuss the coordination with WQCD and the specific pits permitted by COGCC that act as infiltration basins for the treated produced water. And then Rick Allison is going to take over and get into the details of the current permit that has been in place since 2005 and was last renewed in January 2016. And you should be aware, we kind of landed at a similar situation in 2015 when the permit expired last time, and even had to ask for a short extension then. Rick will discuss the permit modification details, and then I'll close with just a brief summary. Next slide, please. So to orient you, the Wellington operations are located in Larimer County, approximately 2 to 3 miles north and northwest of the town of Wellington, which, as you can see on the slide, is north of Fort Collins. The operations are on the west side of Interstate 25. Next slide. So Wellington currently has 18 producing oil wells, 3 injection wells, and a produced water treatment plant that is permitted through COGCC as a centralized waste management facility. And these operations are located in the Wellington field as indicated on the slide. And so that's the long field in the middle of the slide. The smaller one to the east is not associated with this. Next slide, please. So this shows the pits that are also referred to as rapid infiltration basins. In the context of COGCC rules, they are basically unlined infiltration pits that allow the treated produced water to migrate into the underlying box elder alluvium. Although it looks like 4 pits, 2 are connected and are actually permitted as one facility. The Wellington operations, the production varies from year to year, so these aren't exact numbers, but did want to give you an idea that Wellington generates about 1 million barrels of produced water each year. And of that, they treat and discharge approximately 25,000 barrels to these pits each month. And that equates to about 30% of their total produced water. And if you prefer gallons, that's approximately 12,600,000 gallons of treated water going back into the hydrologic cycle annually. Next slide, please. So the discharge of the treated produced water to groundwater was first approved by the Commission in coordination with Water Quality Control Division in 2005, and that was order number 1-108. And I think you're aware of this, but even in 2005, COGCC rules didn't allow for discharges of produced water to groundwater. We were then and still are an implementing agency of Regulation 41, the basic standards for groundwater, established by the Water Quality Control Commission. So at the time, Wellington Operating came forward with the plan, and COGCC worked with WQCD to create the discharge permit. My understanding is that it was a very collaborative effort between the agencies, including Division of Water Resources, and obviously Wellington Operating and the surface owner. So at the time, WQCD provided the specifics of the discharge monitoring requirements, and COGCC permitted the pits and the treatment plant, which, as I mentioned, was permitted as a centralized waste management facility. The original permit authorized the discharge for 5 years, and it has been renewed twice in 2010 and 2015. In each of the renewal phases, we've consulted with WQCD for revisions or updates to the discharge permit criteria. And so in 2020, when Wellington submitted the renewal application in August, you know, we have been trying to figure out how to upgrade this permit to comply with current rules. And it has been a time-consuming effort because additional data from the field is actually needed to do this. So we have relayed the specific data that's needed to Wellington. Rick is going to get into those details. And the result is that a final permit wasn't ready for your consideration at this time. And the current permit expires on February 28th. Because of the additional data collection, an extension is being requested to continue the current discharge under the existing permit criteria until we can finalize the new permit. In addition to the ongoing coordination with CDPHE, I should mention that early on, there was coordination with the Office of the State Engineer, and Wellington obtained a non-tributary determination for the produced water. In fact, each of the oil wells in the field is permitted with Division of Water Resources as a water well. So that's kind of quite a bit of information on the background, but hopefully it provides a good history of the discharge. And now I'm going to hand it off to Rick for more of the technical details, unless you have any questions for me. Yes.
Mr. Chair. I think we got some questions. Sorry, I was on mute. Commissioner Nanjapa, I know you have a question, perhaps others.
Yes, thank you, Mr. Chair. And thank you, Mr. Axelson. I just had just a quick question on something you just said. You said that with the determination from the Department of Water Resources that each of these is permitted as a water well. Does that mean a drinking water well, or is there a different designation for, you know, the use of the water? Could you add a little more detail there, please?
Yes, and I should have looked that up. They're not permitted as domestic water wells, and I don't know if they're permitted as industrial use, but they are not domestic water wells.
Thank you.
Other questions from commissioners?
Mr. Chair.
Yeah, Commissioner Gonzalez, thank you.
Thank you. Thank you, Mr. Axelson. I have a question, just a clarification. What does a non-tributary determination mean, and what's the impact of that determination?
So that basically means tributary water is all of the surface water in the water in the shallow subsurface that's hydraulically connected to that surface water. And so what it basically means is that this is water from a confined aquifer that is not in communication with any surface water or unconfined groundwater. And I'm stepping out of my area of expertise, but it does pertain to water rights and the legal ability of Wellington Operating to be able to discharge this water.
Further questions? Otherwise, we'll turn it over to Mr. Allison for continuation. Mr. Allison, I think you're up.
Okay, thank you. Again, I'm Rick Allison. I'm the Environmental Protection Specialist for Northern Colorado. So I cover Larimer County, where this permit exists. If we could just move on to the next slide. So I'm going to go a little bit into the current permit discharge limits and monitoring requirements. Just talk about the compliance with those. There are basically 2 points of compliance in the existing permit that the operator has to meet. One of those is actually at the outfall from the treatment plant into the rapid infiltration basins or the pits. So that's the discharge pipe. On the permit, it's known as 001A, and that is where the operator is required to meet hydrocarbon limits set in the permit. They're basically the drinking water standard. And then there are some additional inorganic parameters and metals that they have to monitor for, but there are no discharge limits on those at that point. Some of the additional parameters include things like total dissolved solids, chloride, sodium, barium, and boron that are known to be in produced water. And the second point of compliance is a series of monitoring wells that were required to be installed that we'll see on the next figure here in a moment. And they're labeled 50A through E. A being an upgradient well that has no limits. It's designed to monitor background conditions in the Box Elder Creek alluvium, which is the shallow aquifer that's being discharged into. Point B is a monitoring well right on the property boundary. And then there are 3 additional down gradient monitoring wells known as 50C, 50D, and 50E, where there are additional limitations on the water quality parameters for chloride, fluoride, barium, boron, thallium, and then additional monitoring only requirements for dissolved solids and sodium. to date, in terms of the history of the permit, we've not had any exceedances or violations of those conditions. So, the treatment process has a strong track record of meeting the terms and conditions of the permit thus far. If we can move to the next slide. This slide shows the locations of those points of compliance. So if you can see right in the middle of that figure is the label RIBs, and those are the pits that you saw in the zoomed in Google Earth aerial that John showed. And then you'll see a series of red X's, which are the monitoring well points that have been installed as part of the permit terms. So key here being the 50B right on the edge of the pits, and then a quarter-mile down gradient in the ag fields, you can see 50C, D, and E, where the additional requirements are to be met. We can move to the next slide. So I'm going to get a little bit into now how the applicable regulations and rules have changed and why we need to do some modifications to the permit. There's been changes in kind of two areas recently that's driving this. One are actual changes to water quality controls, regulation 41. They added some organics, specifically trimethylbenzene, into regulation 41 that in turn were added into COGCC's rule 915. And then we also want to review the point of compliance against the current regulation 41 to make sure COGCC's setting of the point of compliance conforms to the way Water Quality Control Division sets their points of compliance for these types of permits. And then again, applicable rules that came, some of which were pre-existing and some of which have been updated through Senate Bill 19181 and the rulemaking we just had in the 900 series. Real quickly, 902D requires an operator to prevent pollution, specifically violating the numeric and narrative water quality standards at a point of compliance, and that refers directly back to regulation 41. Rule 905A3 encourages and promotes waste minimization through beneficial use, reuse, or recycling of E&P wastes. In this case, that's the produced water that's treated and then discharged into the pit, approximately 30% by volume compared to total water produced in the field, as opposed to injecting 100% of that water. 30% is being brought up and put into the hydrologic cycle effectively in a shallow aquifer. That was one of the original concepts of the permit, and that still applies. Rule 905C 2D also allows for produced water to be discharged to waters of the state. And while that rule reads a little bit more like it's intended to apply to surface waters, it can indeed be applied to groundwater in a similar fashion with the issuance of this discharge permit. And then Rule 914 sets the criteria that the director should use to establish the points of compliance, where an operator, in their discharge of this waste must comply with the groundwater classifications and standards of regulation 41. So some of the key things we need to look at there are the geology and hydrology of the site. So depth of groundwater flow direction, the hydraulic conductivity, any potential impact to surface water, as well as the potential toxicity or mobility of the contaminants, and any sensitive areas down gradient, such as potential wellhead protection area, or what the use of the groundwater is in this area. And then of course, Rule 915 sets the standards for concentrations in groundwater, which are directly derived from Regulation 41. If we can go to the next slide. So the COGCC staff has requested the operator to provide an update on the site hydrogeological model. Basically, we want some updated information on groundwater flow direction, the depth of water based on the monitoring wells they've been installed and monitoring for the past 15 years. We'll use that information to determine whether that current monitoring well network is adequate to serve as continued points of compliance. We're going to review outfall pipe 1A is certainly going to be the most protective location, and then depending on the parameters and their toxicity and health standards, we may be able to also use monitoring wells as additional points of compliance. So that would again be the 50B, the 50C, D, and E, and the 50A being an upgradient baseline. So we want to review that hydrogeologic data to ensure that that's the correct placement of those monitoring wells. We can go to the next slide. And I just want to, since I listed those out again, kind of refresh how everything is laid out here. You know, the current understanding is that the groundwater generally flows south from those RIVs into the southeast, and it's an unconfined aquifer known as Box Elder Creek alluvium. It's very coarse grained. Basically, the idea is there's a paleo channel in the bedrock in this area that was cut by the Paleo Box Elder Creek, or ancestral Box Elder Creek, if you will, and it's now serves as an unconfined aquifer. And we think the monitoring well placement is likely appropriate, but we, given the time that's gone on and the regulatory changes, we want this additional data just to back that idea up. The next slide. The next slide, so this details the second key piece of information we want to pursue, and that's characterization of what the untreated produced water looks like. This was done in 2005. We feel it's an appropriate time to recharacterize. There are additional analytes we're concerned with. So first being are the organics listed in Regulation 41, and we're really focusing on just the hydrocarbons of Regulation 41, not additional organic compounds such as pesticides or herbicides or chlorinated solvents, things that are not associated with oil and gas. So we're just dialing that into hydrocarbons. There's a table in Regulation 41 that has lists human health standards for domestic water consumption. Those are certain metals and other ions that have a toxicity component to them. And so we're having the operator analyze that complete table. There are additional drinking water standards for ions such as chloride, iron, manganese, sulfate, zinc, pH. There's no health standards for these. They're more of a general water quality or anti-degradation standard. And so, you know, we're going to use those to kind of compare to the background aquifer and view that through more of the lens of anti-degradation of the water for the intended use in the area. That also leads to the agricultural standards in Regulation 41. Because the primary source of water in this area is irrigation. There are very few domestic water wells for drinking water, but there are water wells for livestock use. And if you remember back to the slides, you could see the crop circles. There's definitely irrigation in the area. Radium-226 and 228 are the key, a subset of radiological standards in Regulation 41. And we're having the operator reanalyze the untreated water for these isotopes based on COGCC's produced water norm study. These are the parameters we would expect to find in produced water. And so we want an update on whether or not those are present, at what levels. Should we set a discharge limitation on radium? The next class of compounds is Pfas, and this is kind of a new emerging contaminant over the last 5 years, 10 years. That WQCD recently put out a policy, a narrative policy for Pfas. Pfas stands for per or polyfluoroalkyl substances, and they're basically synthetic substances that are used in a wide range of applications in society, and found to be present most commonly with firefighting areas is probably the big one that's heard in the news. But there's also a potential for these compounds to be used in additives in the oil field, in surfactants. And so we did review those additives with the operator and their safety data sheets. And none of those sheets specifically lists that a fluorinated surfactant or a Pfas is being used. But at the same time, if they're in a small enough amount, they could still be present in those additives and not, by regulation, by OSHA, not be listed on a safety data sheet. So in abundance of caution, and since the target and limitations for these Pfas are very low concentration, we're working with the operator to identify labs that can analyze for the target. There's about 20 or 25 Pfas compounds listed in the narrative policy. Again, that's not something we really expect to be present, but there is a potential. It could be in an additive like a corrosion inhibitor or one of the breakers that might be used in the upstream process. And so we want that data to provide the certainty to the idea that they're not going to be present. And then finally, total petroleum hydrocarbons is really for two reasons. This number isn't a number that's really regulated in Regulation 41, and it's not regulated as there's no groundwater standard for total petroleum hydrocarbons. The standards are for those individual hydrocarbons like benzene, toluene, ethylbenzene, xylenes. But COGCC has a new rule for pits, Rule 909J, that requires operators to sample produced water being placed in pits, and TPH is one of those parameters. So we're just adding that at the same time for efficiency's sake to help the operator comply with that rule. And then the next slide, please. So after we obtain the hydrogeologic data and this additional characterization data, we'll review those together to modify the discharge permit. We'll see what parameters we might need to add, where we should set the discharge limits, be it at that outfall point or one of the monitoring wells. We'll consult again with our colleagues at Water Quality Control Division and get their input on the modified permit, and then bring it back to the COGCC for consideration to renew for what in the past has been a 5-year term. And that would be the idea going forward later this summer. Now, I believe we have one more slide. We could have the next slide.
So yeah,
thanks, John.
Pick it back up with kind of a conclusion. So as discussed, Wellington is requesting an extension of the current discharge until August 31st of 2021. And that's to allow enough time to collect the additional data that we've discussed and to develop new permit criteria in coordination with WQCD. Due to the established record of compliance by Wellington and our current knowledge of the produced water quality after treatment, COGCC staff supports the extension request. We do not believe there is a heightened threat to groundwater resources, but it's obviously time to reset the baseline and provide assurance through an updated permit that the environment is being protected pursuant to all of the new applicable rules. And so that ends our presentation.
Excellent. Thank you, Mr. Axelson, and thank you, Mr. Allison, for the very thorough presentation to us this morning. This time I would look to commissioners to see if there are any comments. I also would like to provide the operator, Wellington Operating Company, and Mr. Evans an opportunity for comment if he has any. Mr. Evans, maybe we would recognize you first and then we would go to questions for the entire panel.
Thank you. I agree with the presentation that was put on by Mr. Axelson and Mr. Allison. I've tried to work closely with them to maintain this facility, and I've got really no further comments unless there's questions about the facility itself. I'm the operator in responsible charge, not the oil field operator. So I just wanted to clarify that. That's
great.
What I've got for now.
That's perfectly acceptable. Thank you very much, Mr. Evans. I appreciate your being with us as well. So now I am looking to my fellow commissioners to see if anyone has questions. Commissioner Nanjapa, followed by Commissioner Hackett.
Thank you, Mr. Chair, and thank you very much, Mr. Axelson and Mr. Allison, for the presentation. I thought it was very thorough. And just one question, and I may have just misheard. I think, our agenda item was with respect to treated produced water and kind of extending the permit on that. But I think in your steps, you had in step 2, obtaining a characterization on the untreated produced water. And is that just simply because you are trying to understand what's there before it gets treated, and that the extension is still going to be for water that will be treated? Is that correct? Did I understand that correctly?
Mr. Axelson or Mr. Allison?
Yeah, I'm going to take that.
Yeah, Commissioner Njapa, yeah, you're correct. The reason to sample the untreated produced water is to characterize what's coming into the plant so that we can see if we need to look for anything additional beyond what's in the current permit conditions. We don't think that we do, but again, we're kind of resetting that baseline to provide that assurance. And then you're right, the extension is to continue to place treated produced water in compliance with the current permit terms into the pits.
Okay, thank you very much for that clarification. And I appreciate the comments from both of you and from Mr. Axelson with respect to the operator having been in compliance and that there's no perception of heightened threat, but also really appreciate this opportunity for resetting the baseline. So thank you again for the presentation.
Commissioner Hackett.
Thank you, Mr. Chair, and thank you, Mr. Axelson and Allison, for your presentation. Just had a couple of comments and maybe a question. I think the question might be for Director Murphy or hearings officer. But first, just wanted to say I have participated in some of the coordination discussions with the Water Quality Control Division and the subject matter experts over there, as well as Mr. Allison and Mr. Axelson. So just wanted to thank the two of you for being so informative during those processes and being so flexible. And clearly this is an issue that you understand is very important to coordinate with CDPHE on, so we appreciate that. And also the outcome that you are recommending today not surprised by that at all. That's consistent with the previous discussions we've had. So that's something that CDPHE can get on board with. And we look forward to having additional coordination meetings with you all on that. So please let me know how I can help set that up. But in terms of a question, so substantively, no surprises there, and I'm on board with what's being proposed. But in terms of procedure, I'm wondering if maybe if I missed some sort of notification about this agenda topic. I was a little surprised to see it on the agenda, and I would have hoped to have a little more upfront notice to CDPHE. I understand staff is incredibly busy and it's really hard. It's a big lift for hearing staff to put together agendas and especially on topics on such short notice. So no criticism there. I'm just wondering going forward when the Water Division participation might be useful in the hearing for reviewing this permit and renewal application. If there is some advance notice that we could get, I'll be able to coordinate schedules and get them to participate in that hearing.
If I may, Chair.
Director Murphy.
Thanks. Commissioner Hackett, apologies. This was raised with me and slipped off my radar in terms of getting it on the agenda. I'd like to go ahead and just put out a gigantic I miss Mimi comment. She helped me organize and stay on track in ways that are innumerable, and trying to pile her work onto John Peskin's has been an unbearable load. So someday I will do better about getting organized, and thanks for your grace. We will coordinate more closely and make sure that water quality has the opportunity to participate in the subsequent hearing if they want to, of course.
Mr. Chair, if I could. Yeah, and thank you for that, Director Murphy, and absolutely no need to apologize. I totally get that, and I think we all do miss Mimi too. So appreciate that and look forward to more coordination on this.
Other commissioners with questions? Commissioner Messner.
Thank you, Mr. Chair. I'm happy to make a motion if it's appropriate. And so I will move approval of docket number 200800228.
We have a motion. Do we have a second?
Second.
We have a motion and a second. Is there discussion on the motion? Seeing no discussion, all those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? Great, motion carries. Mr. Axelson, Mr. Allison, Mr. Evans, thank you all for your presentation. We have done this extension and we'll look forward to hearing from you later on. All right, we are now at commissioner comments. Before we get to commissioner comments, we did have one recommended order on our agenda for the public. The way that works is that is an enforcement order, and if we take no action on it, it becomes an order of the commission. I generally like to make sure that everybody's comfortable with that. Are there any questions relative to the recommended order? Commissioner Mcgowan.
Thank you, Mr. Chair. Yeah, I read through the order and I just had some questions or maybe some clarifications that might be provided by staff, and I sent them to staff yesterday so we could talk about them today, and I don't know if they were able to answer everything or not. But I was curious to know how many locations Bison has that will be included in their audit, their stormwater plan. Does staff have a plan for visiting the other Bison locations? Have they already visited some of the locations and noticed similar violations for stormwater? Have they had compliance issues? And how did the final penalty amount and the clawback amounts get determined? It looks like the actual penalty is actually only 40% of the total. The clawback was more than that. And then this is the first time that I've been told about a clawback type of enforcement, and I'm not very familiar with it. And I'm wondering if staff could talk about why did we put a clawback in place as a solution, and is there a benefit to this kind of a strategy for a violation? And if we could talk a little bit about using clawback as a tool.
See that certain members of staff have joined us. Director Murphy, do you want to call upon the appropriate staff member?
I sure would. I would love to hand this off to Enforcement Officer Costanet to jump into Commissioner Mcgowan's questions. And of course, Commissioner, if we miss a couple of those, please re-ask them. Although I just see that, oh good, Matt's back. Whew, he just disappeared.
Yeah. I see that we have Mr. Costanet. If my notes are correct, I think there were 5 questions. And Mr. Costanet, you might set the scene just because we are before the public and they've not seen that. So if you could sort of set the stage in terms of what this is about, and then if you could work on the answers to Commissioner Mcgowan's questions, we would really appreciate it.
Thank you, Chair Robbins. I'm Matt Costanet. I'm the enforcement officer responsible for this matter. As a general background, the operator in this matter is Bison Oil and Gas 2 LLC. The alleged violations in this matter arise out of violations of Rule 1002F at a Bison location in Weld County. And those violations were observed by staff during 2019. And staff worked with Bison and its counsel to agree to the terms of the AOC that's before you. And that's I guess, a general background of what is the nature of the violations. There's a lot more detail in the AOC in terms of the history of the violations, what was observed there. As far as Commissioner Mcgowan's questions, at least the first question related to locations, according to our information, Bison has 50 active locations. And so out of those 50 active locations, actually 7 of them are not constructed and the Form 2As have expired. So really the universe of locations we're dealing with here is 43. Out of that 43, 16 of those are constructed and have facilities on them. So that's a combination of multi-well locations as well as single well locations and other associated facilities. The remainder of that 43 have valid 2As, and those 2As expire the latter half of this year and as far out as 2023. Now that's based on our information. There are representatives from Bison that are available on the call as well. It may be the case that some of those unconstructed locations have in fact been constructed at this point. Our data maybe has not caught up to that yet. Additionally, at this time, Bison has 18 pending 2A applications. So there are 18 additional locations that they're seeking approval. So I think that gives you a sense of the universe of locations that would be subject to this agreement. And I think your second question was about plan for visiting the Bison location. So there's no specific plan under the terms of this AOC to inspect Bison locations as part of this agreement. Bison's locations will be inspected in the ordinary course of business as part of the compliance unit's inspection activities and the priority they set out for that. I'd have to defer to Mike Leonard, if he's still on the call, as to how that priority system works, give you more explanation about that. I don't know if he's still on the call. Your third question's about any compliance issues since the NOAV. So the NOAV in this matter was issued in January of 2020. Bison locations have been inspected since this NOAV was issued. And I'll just back up and say, this is the only NOAV that's been issued to this operator. So since this NOAV has been issued, there have been inspections of Bison locations, including inspections for reclamation related issues, and there have been no corrective actions for violations out there during those inspections. And then how is the final penalty amount determined? So generally, we have done arrangements like this in the past where we have an upfront penalty being paid and some amount of the penalty being suspended, and Clawback's probably a new term here that hasn't been used previously, but there has been what is effectively a clawback under those other agreements, where to the extent there is a subsequent episode of noncompliance under one of these other agreements, that suspended penalty amount can be clawed back, can be unsuspended and due and payable under the terms of those agreements. I think this is just an agreement that's building on those earlier agreements. 40% is generally the upfront payment we use under those agreements. There have likely been some where it's been a little less than that, but 40% has generally been used. We're looking at that, and 40% is an amount that we feel, and in this case, felt was appropriate given the nature of the violations at issue. And so in this particular case, to elaborate on that a little bit, this isn't a situation where we have an operator was being cited at inspections and did absolutely nothing. They were taking steps to correct the violations here. I would say that they just weren't getting it right, would probably be the way to explain that. So they were taking steps, they were being responsive to the inspections, responsive to the corrective actions. It just wasn't quite clearing the bar necessary to bring those issues into compliance. So that's how that 40% comes up. And then the clawback amount, the remaining amount, is what's left over after that 40%. And the purpose of the clawback is kind of a carrot stick proposition. So there's some amount of penalty that's paid up front that serves the purpose of deterring compliance and ensuring compliance going forward. And then for the term of the agreement, there will be effectively a looming potential penalty that could come into play to the extent there are subsequent periods of noncompliance. So that's the stick component, and the carrot is if the operator is, and in this case Bison's, able to stay in compliance with 1002F at its locations, then the suspended portion would be vacated at the end of the agreement. So the carrot there is that suspended portion of penalty would be vacated in full or in part, depending on how the circumstances work out.
So,
Commissioner Mcgowan, follow up.
thank you, Mr. Chair. So is the clawback, so if you were to go inspect a location and there was another stormwater violation, is the clawback then in addition to the violation that would be incurred for the inspection? Or do you see what I'm saying? I'm trying to figure out, there would be a penalty anyway if we inspected and they still were struggling with stormwater compliance. And so is the clawback would be in addition to an additional violation? Sorry,
No, thank you, Chair Robbins.
Yes, please.
The traditional enforcement tools for any subsequent violations will still be available. So it's really more of a, what do we see, and we'll evaluate that subsequent violation and say, does this make sense to use this clawback mechanism, or do we want to pursue a traditional enforcement action for those subsequent violations? I mean, an example of why we may want to pursue the traditional enforcement is perhaps that subsequent non-compliance is very severe and it's a long duration violation, and the penalty associated with that violation is, I don't know, say $50,000 to $100,000. Well, perhaps it doesn't make sense to use the clawback because the penalty that would be associated with that would be $18,000 and change under the terms of the agreement. So that's an evaluation that's going to happen based on looking at those subsequent periods of violation. This is another tool that we can use to address those subsequent episodes of noncompliance. I would also add that this also, an advantage to this clawback is that it's administratively more efficient. So to the extent there's a subsequent episode of noncompliance and we want to pursue a clawback in that situation, we would not have to go through that traditional enforcement process of putting together an NOAV, serving that on the operator, and then going through the whole process that we typically go through in terms of potentially negotiating an AOC or bringing that matter to a full adjudicatory hearing. Instead, if the circumstances warrant it, we could just use this agreement to claw back that amount and have that penalty based upon a demand to the operator without hearing.
Thank you.
And I think sorry, Chair Robbins.
Go ahead, please.
I think Commissioner Gowan, I addressed all your questions. Hopefully I did. If there's anything else, please let me know.
Yeah, that was very helpful. Thank you. And I think I was just trying to decide, or by reading everything, whether or not maybe why they were struggling so much to come up with an appropriate stormwater plan, if they lacked expertise or consultant or what was going on, or if it was, I'm not using the right words, if it was purposeful, that they were just not complying. And it sounds to me like what you're saying is that there was good intent and they were trying to get it right and just were missing the mark.
Chair Robbins.
Yes, please.
Yeah, I would say that would be staff's conclusion. Certainly representatives of Bison are on the call. They could probably provide you much more detail about what issues they may have encountered that contributed to their inability to be in compliance in this particular matter, whether those were struggles with contractors or whatever the case may be. They'd certainly have more detail on that.
Commissioner Najapa.
Thank you, Mr. Chair, and thank you very much, Mr. Castanet, for the explanation. That was helpful. I just also wanted to make sure that I was really clear on kind of what was being requested. So with the audit, this will be within 120 days. They need to look at all of their locations that are applicable and determine if there's compliance and take any corrective actions. And what is I have a couple of parts to this question, but first is, what is the obligation of staff during this 120-day period? Like, can they ask you at any point to come and look at something that they're in the process of fixing or have thought that they have fixed? And, are you sort of on call as this is happening, or yeah, can you explain that part at least?
Mr. Castanet.
Thank you, Chair. There isn't anything specific, again, in the agreement that is going to place an obligation on staff to go out during the audit period and see what Bison is doing in terms of its audit. However, to the extent staff does inspect the Bison location during the audit period, under the terms of the agreement, they have the ability to request any internal documentation that Bison has put together that has been assembled as far as or as part of the audit to address any non-compliance they discovered at a location, the steps they took to bring that location into compliance.
Commissioner Najapa.
Thank you, Mr. Chair. Thank you, Mr. Castanet. I think okay, so if during that period, if the staff happens to be out and inspecting a location, they notice anything, they can add additional conditions or deadlines to continue to perform the corrective actions. And then after that 120-day period, Bison can ask for a staff inspection, or I guess it says at one meeting with staff following the 120-day period. Is there an intent or a requirement at all, this is kind of related to my last question, to go and look at all of their locations that they have inspected themselves and determined, whether or not was in compliance? How do we know for sure, I guess, that they have met the compliance requirements within that period?
Mr. Castanet.
Well, as far as the audit period goes, thank you, Chair Robbins. As far as the audit period goes, again, Bison will be self-regulating themselves in this situation. They can ask for that meeting after the audit period. The meeting has not been contemplated as a let's visit all the locations and confirm what's been done. That's a discussion we can have with Bison in terms of when they make that request as to what they feel is necessary, and staff would be involved in as far as what would serve the purpose of assisting them in ensuring compliance on a going forward basis. But I would say that that meeting is contemplated as a sit-down meeting to say, hey, we went through and did this audit. We have some questions about what we may be looking for from a technical perspective and what they've been doing, so that for the remainder of the term of the agreement, they can frankly shape their activities to try to ensure on their part that they avoid the clawbacks.
Thank you very much, Mr. Costnet. My final question is just so then there's after the 120-day period, or maybe it's actually overlapping, the 2-year period allows for sort of ongoing work and just ensuring that they're compliant within that 2-year period, just with sort of regular staff inspections. Am I understanding that correctly in terms of, whether or not there's any need for the clawback to come into effect?
Mr. Costa?
Thank you, Chair. Yes, I'd say it's building upon that audit. So again, we're looking to Bison to self-regulate and take steps necessary to continue to keep their locations in compliance, and to the extent they do, internally document that. The opportunity for staff to observe a period or an incident of non-compliance that could trigger a clawback is going to be, again, based on the regular inspection process that the compliance unit would have for locations in Colorado.
Thank you very much, Mr. Costanet. And then just a comment in that I read the letter from Bison in response to the NOAV, and I do appreciate that this was their first non-compliance event, and that they were trying. But I did also feel that there was a bit of we hired these contractors, we thought they were going to do the job, and they didn't. And I just want to remind everybody that this is ultimately on the operator to ensure the compliance, and to, I guess that was part of what I was wondering, is if there's ever a question, am I correct in understanding that they can contact staff to verify, whether with photographs or a site inspection, if something is in compliance, if they're unsure if a contractor has performed something correctly?
Mr. Leonard?
Thank you, Chairman. Commissioner Nanjapa, yes. We encourage our operators to talk to staff if they have questions or concerns. We really want to solve the problem before it becomes a problem. As you know, stormwater is a very complex and difficult thing to manage. All compliance unit inspectors are trained in stormwater management. So it's not just necessarily a reclamation inspector looking at everybody's looking at it. Going back to the notices this morning, the notice of constructions, the reclamation specialists prioritize those notice of constructions to go out and make sure that the stormwater protections are put in, and they're put in properly. We have over the years had problems with, we haven't had problems with contractors, but I know operators have had problems with contractors that are not quite getting it right. But if they have a question or they want, we don't give advice because we can't, right? We can't engineer that job. But if they have a question as to whether that's effective or not, or if it's installed, or, maybe some suggestions of what might work, we can always do that.
Thank you. I really appreciate that, both Mr. Costnet and Mr. Leonard, for those clarifications. I think, again, it's really important that, understood that operators may need to hire contractors for different jobs, but glad to hear, that the staff is available and willing to assist or answer questions to ensure compliance, and, just making sure that all the operators are taking advantage of that as needed to, but, ultimately that it's their responsibility to ensure that their contractors are in compliance. Thank you.
Commissioner Messner.
Thank you, Mr. Chair. I think just an opinion from one commissioner. While I appreciate the creativity of the clawback concept, you know, the way that I look at this is that there's been a violation that's occurred, and certainly I'm interested in the carrot and the stick concept. But with a 6-part clawback, we're essentially saying that we're allowing an operator to have 6 more violations and only have to pay their original penalty. And so I would encourage, you know, if a percentage up front and a clawback be used in the future, that it be a single clawback amount for the full amount of whatever was not paid up front for a future violation. And that in this particular instance, if there was future violations, that both an NOAV and the clawback be administered, so we do not have a pattern of violation, because I would assume that if we had 6 different incidents that would require the 6 different clawbacks, at that point we're talking about a pattern of violation. Having said that, I do understand very much that this is Bison's first attempt, and I do appreciate Mr. Leonard indicating that staff is always available for operators to reach out to ensure compliance, and particularly around stormwater, which I actually, as an individual commissioner, think is an incredibly important part of operations. So not a question, just a comment. Thank you.
Chair.
Director Murphy.
Thanks. I wanted to clarify one piece. Enforcement Officer Acostanet talked about pending 2As, and we use pending in a lot of different ways in our organization. In that context, what was referenced are 2As that have been approved but have not been constructed. I just wanted to clarify, because this morning I said we don't have any pending 2As, and we don't. We haven't received a new 2A, but Bison does have permits that were approved under the prior to January 15th.
So Director Murphy, is that the 18 that Mr. Costanet referenced?
Correct, yes.
Because I actually had written down, are those pending, meaning they need to be replaced by March 1st with a new permit application, or are they, and you just clarified, they're pending, meaning that they've been approved and they've not been acted upon?
Correct, yes.
Okay. Further discussion? Okay, so at this point, again, this is a recommended order, and if we do nothing further, having had this discussion about it, it becomes an order of the commission. I understand at least one commissioner, Commissioner Messner, you had a comment about it, but it didn't appear that your comment was to go so far as to go to the next step, which would be to actually not allow it to turn into an order and instead remove it from the agenda and allow staff to go back to the drawing board. Am I accurate there, Commissioner Messner?
Thank you, Mr. Chair. That is accurate. I mean, I didn't read anything in the order that would not allow future actions to include both a clawback and an NOAV, which is what I ultimately was recommending. And then I made a comment around, you know, future utilization of clawbacks and how that could be structured, perhaps not in 6 parts, but in 1 part.
Okay, so I think that should be noted via our enforcement staff, but unless I see otherwise, we will leave this on the agenda and it will become an order, and we will move on to our next agenda item, which is our last agenda item, which is, are there any commissioner comments? I guess, you know, my only comment is I was going to echo what Director Murphy started with, which was for the world at large, we did appear before the Senate Environment and Transportation, or Transportation and Environment, I'm not sure which, or Energy. Anyway, a committee before the Senate who was supposed to determine whether to confirm us to the full Senate, and that occurred yesterday, and all 5 of us were indeed confirmed to the full Senate, which should have a confirmation hearing on us shortly. So pleased about that. I echo Director Murphy's thoughts. I appreciate some of the positive comments that were received. That occurred this week. My only other sort of update of actions that I've done this week is I had an extensive meeting with Executive Director Gibbs, CDPHE Executive Director Jill Hunsinger-Ryan, myself, Director Murphy, folks from CDPHE with the Southern Ute Indian Tribe. We had a consultation on Monday for about 4 hours in which we explained to the Southern Ute Indian Tribe what's been going on in COGCC world for the last year or two. CDPHE did the same thing with regard to their world. We heard from the Southern Ute Indian Tribe about oil and gas development and what's happening on their world. And I think, we all sort of pledged to keep each other informed, which I thought was a very good meeting with the Tribal Council. That's kind of it for my commissioner comments. Do any other commissioners have comments? Commissioner Vogt.
Thank you, Chair. I just want to give a quick comment on behalf of Director Gibbs, who I'm representing today. He just wanted to say congratulations to all of the commissioners on their confirmation hearings yesterday, and just to say a big thanks for all the great work that you have done over the past year and that he's looking forward to in the future. So thanks again.
Thank you very much, Commissioner Vogt. All right, seeing no further comments, I think we've reached the end of our agenda. A good productive session this morning, everybody. Good to talk with everybody. At this point, we would look for a motion to adjourn.
So moved.
Second.
We have a motion and a second to adjourn. All those in favor indicate by saying aye.
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 Any opposed? We're adjourned. Thanks, everybody. See you next week.